Hey everyone, I hope you guys are doing well. I wanted to bring you a video on 7 steps on how to remove a collection. Now, if you're new to my channel, please subscribe to my channel and understand this channel is dedicated to credit education, no matter where you are in your credit journey to improve and maintain your credit score. I am not credit repair. I no longer give consultations. I haven't did so for 2 years. So if you have someone to comment to you in the comment section using my photo, make sure you click on the photo and see if the subscriber count matches this channel, because if it doesn't, it's a scammer. So please be careful, you guys. You can always contact me at my website. It's always in a link in the description of this video or in the pinned comment sections. And if you have personal questions, you can submit your comment there. But if it's general, just put it in the comment section. Now, when it comes to collections, many of these collections are what's called third-party collections, meaning that the original creditor sells a debt. So if a debt is owed, generally for 180 days, that original creditor will sell that debt and write that debt off. So many a times it'll appear on your credit report from that original creditor as a charge off or a write-off, and then they may sell that debt to a third-party collection company. So with third-party collections, the credit bureaus have recently made up a rule for any medical debts, and this is for medical debts only, under $500 that you pay will be removed from your credit report starting July 1st, 2022. Now, any medical debts that has just been created has to sit on hold for at least a year before they can report it now to your credit report for medical collections. So you want to know there are different types of collections. So they are medical collections. There's consumer collections, like from your credit report. Then there are collections from just having a rental unit or renting an apartment. And depending on the particular type of collection, you need to understand how was that created, because when it comes to these third-party companies, they have to show legal right to collect on that debt. They have to show proof that they purchased that debt. And with you and the original creditor, you have to give them a legal right in order to sell that debt. So in instance of a credit card, many people will apply online, get that credit card in the mail, and never sign that contract. So you never gave them a legal right to sell that debt. So that third party couldn't purchase that debt if it was never sold. They have to show where you gave that original creditor permission to sell that debt. Now, you have to be careful with third-party collectors and speaking with them on the phone, because what happens with them, they know that many times they don't have legal right to collect on this debt. And also, these kinds of debts are sold over and over again. You might get one company, collection company, for one debt to contact you. Then you'll see a whole different name of a company, a collection company for that same debt contact you. So they keep selling these debts, and they have to have chain of title to show that they purchased it from this company, from the next company, from the next company. So if I steal something and go out on the street and sell it to you, and you actually paid for it, I didn't have legal right to sell that stolen item. So they have to prove they have a legal right to actually collect on this debt. So what they do when they call you, number one, they record the phone call, because what they're trying to do is create a verbal contract with you. If you just want to do this little experiment, simply tell them when you call, when they said, this is a recorded line, just tell them, I'll talk to you gladly, but I don't want to talk to you on a recorded line. Please call me back on a non-recorded line. They will say, I cannot do that, and they will hang up, because they know that they're trying to trap you to make a verbal agreement. Once you make that verbal agreement or make a payment, you then agree to do business with them. They understand. They never gave you a taxi ride, any goods, any services, so they cahoots you guys to create a contract with them. So step number one, when you get contacted by these companies, you need to send a debt validation letter. I have these letters in my packages at my website. Now, a debt validation letter is your right under the Fair Collection Practices Act, the federal law, to make them prove they have a legal right to collect on the debt. If you send out that letter when they send you notice of a collection and you do it in that 30-day window, they cannot report that on your credit report until they give you some kind of proof that they purchased that debt. So that collection can't go on your credit report until they do that. If it already passed that time, you still have a right to send a debt validation letter. You want to be careful with talking on these people on the phone or making them a payment without proof, because if you pay them or make an arrangement, you can also reactivate the statute of limitations in your state. A statute of limitation is a time frame, depending on what type of debt it is and your state laws, that they can sue you. Sometimes it's 2 years, sometimes it's with 3 years. And many a times this time period have passed on these debts because they've been sold. But if you agree to do business or make a payment, you can be sued. So you want to be very careful and always send a debt validation letter directly to the collection company. And you will always send this certified mail. Now, after you send your debt validation letter directly to the collection company, certified mail, your next step is you want to wait 30 days and look at your credit report. And you want to look at that collection. If that collection is not updated as being in dispute with notes under that account, then you need to take step number 2. And step number 2 is sending a dispute letter to the credit bureaus, because the collection companies are violating the Fair Credit Reporting Act. They must update that account as being in dispute anytime they receive a debt validation letter. So if they did not do that, they're in clear violation of the federal law, and that account needs to be removed immediately. So what you need to do is write that to the credit bureaus, and it's their responsibility to remove that account. Then you need to take a look at the charge off itself, and you want to see how the charge off is reporting. When you check your credit reports, you want to see if the original creditor is reporting a charge off for that account connected to the collection. If so, it has to report, as you see on the screen, as the balance being at 0. If not, that's a violation of the Fair Credit Reporting Act. Now, in this example, this charge-off have a balance of $6,297. So if you have a collection with the same balance of $6,297 reporting, then there's a total of $12,594 worth of debt for one account, when it actually only needs to be $6,297. Because if you have the charge off with the balance and the collection reporting that balance, they are really creating a double jeopardy situation for you. So you need to dispute both accounts, because they cannot report both accounts with a balance. You want to include these errors in your dispute and send your dispute certified mail. Make sure you take screenshots or copies of this inaccurate reporting, because you will need it for the steps later on. And make sure every letter you send out is via certified mail. Now, after you sent off the dispute letter to the credit bureaus, certified mail, you're at the step now where three things could have took place, okay? Only these three things. So the first thing is the debt is removed. Because many times when these collection companies reach out to you and you send them a debt validation letter, they don't have the proof. So they don't want to be bothered, because a lot of times they just purchase this stuff in a big, large portfolio. So they're just buying a package, and they may not have that information or can obtain it from the company that they purchased it from in that 30-day time period to produce the proof. So some will remove them, and you disputing with the credit bureaus, they didn't update it, they would just remove the collection. Number two, what could happen is that these companies will respond back with a bill from the original creditor. If that is the case, it is still not proof that they have a legal right to collect on a debt. This is them deflecting from what you are asking for. Now, if this is a medical collection, that is even worse, because under the HIPAA law, they are not supposed to have your personal private health information. So if they send you back a health bill with you going to radiology or just anything in the health department, they're in violation of the HIPAA law. So I have letters in my packages to address this situation. So the third step, you're going to send a second response debt validation letter. If it is just a phone bill and they send you back a bill, your response is going to be that proof of a debt being owed is not legal right for you to collect on the debt. We all owe bills. I owe a light bill. You owe an energy bill, but I just cannot show up on your door with your energy bill and tell you to pay me, because you never did business with me. You don't know who the heck I am. You will call the cops on me. That is extortion. And so it's the same thing with them. I have to show you proof that I have legal right to collect for the energy company, because you may owe them, but that doesn't mean you owe me. That don't mean you owe me. So you might have borrowed from Bank of America and owe them a debt. I just can't say, well, pay me the money you owe Bank of America. I can't do that. I have to show I have a legal right to collect on the debt. So that's going to be your response. And if they don't prove that, they have to remove it. And if it is the option where it is a medical debt, then I have a letter, or you can write up your own letter letting them know this is a violation of the HIPAA law for you to have my personal medical information. And many a times they know that, and they'll remove that collection because they are in violation. So with that third step, if it was not removed, you are going to send a second debt validation response letter. And those are the reasons why that you need to take those steps. Now, once the credit bureaus complete their investigation, they're going to either remove that negative collection or they could update it. Now, here's your options. If they remove it, great for you. It is removed on the credit bureau's end, and there's nothing further you have to do. But if it remains, you want to move on to the fourth step, and that is to review all 3 credit reports and look at something that collection companies always do. And what they'll do is re-age that debt. So you want to look at the original charge-off. Find the date that you last paid on that charge-off and make sure that it is correct. If it's the last month you made that payment was in December 2017, make sure that is correct, because if that's reporting inaccurately, you can dispute that too, because they have to start the clock of the 7 years that that item can remain on your credit report by the date of last payment. But what collection companies will do, if that account was paid last on December 2017, they'll update their collection starting May 2022, so they can extend the time to keep reporting that negative account on your credit report. So you want to look at, is those dates consistent? If the charge-off date of last payment is incorrect and the collection date of last payment is incorrect, or when they're reporting that date for that collection, then you need to dispute that for re-aging, because that is a violation of the Fair Credit Reporting Act. The reporting has to be 100% complete and 100% accurate. So if you find any other inconsistencies, even from other credit bureaus, for that same account being reported, remember, it all comes from one source. That is the collection agency. That is the original creditor. They're the ones reporting to the credit bureaus. So you can't have a different date for TransUnion, a different date from Equifax, and a different date for Experian for one account, because they're the ones doing the reporting. So that means they're re-aging the debt and the information is inaccurate. So you want to dispute that with the credit bureaus directly. Always send all your letters certified mail, because we're moving on to the 5th step. Now, after you take in those first 4 steps, and if that negative item, that collection or charge off haven't been removed in connection to that collection, you're going to initiate this 5th step. Now, this is the reason why you were sending everything certified mail, because you needed proof. And now what you're going to do for the 5th step is go to the Consumer Financial Protection Bureau. They are the one that oversee the credit bureaus and these collection companies. And what you want to do is go there and file a complaint. I will leave the link to their website in the description of the video. And you want to make copies of all your letters, your certified mail. I also suggest you take screenshots of that negative reporting that the bureau heads did. Make copies so they can't update it, so you can keep a track record. And then you're going to file a complaint to the Oversight Committee, which is the Consumer Financial Protection Bureau, and they're going to process an investigation so you can get this removed. You always want to have proof of their reporting, because if they are not 100% complete and 100% accurate, then that negative information must be removed. Now, the sixth step you can attempt is a pay for deletion. Now, I will warn you guys with this step, because as I told you guys earlier, they record your call and you have to be very careful. Review your state laws, because just by attempting or saying something incorrect, you could open yourself up for a lawsuit by doing this. But with this pay for deletion, you need to watch what you say to see if you can put in an offer. Remember, if you tell these people that you're going to pay them without watching your words very closely, you could set yourself up. You want to make sure, if you're doing a pay for deletion, that everything is in writing. Don't believe these people when they say, okay, yeah, you just pay us, yeah, we'll remove it. No, they'll update it as a new negative item if you're not careful. So you want to make sure that you proceed with caution in taking this step. But a pay for deletion is paying them and asking them to remove all negative reporting, that negative item for the payment. Nowadays, they are not really apt to do this like they were in the past, because the credit bureaus sell data, and these companies have a subscription plan which requires them to report a certain amount of names every month. Remember, collection companies need the credit bureaus or they wouldn't have any power. The credit bureaus need negative data to sell to the banks as credit reports to make money, because banks pay more money for subprime credit because they can charge you more interest. Banks only make money off of interest and annual fees primarily. So believe it or not, they buy subprime credit reports at a higher price, because I can lend you $300 and then charge you 29% interest. Somebody with really good credit, I can't do that. And it's competition over that really good credit person's profile that they can get a multitude of offers. So be careful when you go with the pay for deletion not to reactivate a statute of limitations or bind yourself in a verbal contract. Now moving on to step number 7. Now with this, I'm going to give you this disclaimer. I am not an attorney, and this is not constituting as legal advice. This is for educational purposes only. But step number 7 is a step that I have done myself personally, and that is bringing a small claims court lawsuit against the collection company, especially for debts that's $1,000 and less. And the reason why I have done that, when I have done those prior steps and the collection company did not produce proof or a contract or anything showing that I owe them a debt, in my state, I processed what's called a defamation lawsuit in small claims court. Because here's the thing. If you're saying that I owe you $500, but you don't have any proof that I owe you anything, you are deframing my character. Your credit is directly connected to your character, and I can't get housing. I can't get a car. I'm paying higher interest rates. So you're causing me damage for a lie. Let's just say I owe the money to someone and I owe you $100, but you're reporting I owe you $500. You're still lying on me, because guess what? If it was only $100 being reported on my credit report, I might have got that apartment. I might have got that car. I might have got that credit card. So if you have no proof, you're lying on me. So what I have effectively done in the past, and like I said, these are for debts, smaller debts, $1,000 and down, I have personally went to file a lawsuit for defamation of character, because that's on generally every state have a defamation. And I will file a small claims court lawsuit against the company and their board members. Okay, I would grab as many names as I can and some customer service reps names. I will go to the Better Business Bureau and grab them names up of their board members. They're the ones that make the personal decisions. And guess what? I would name them personally in my lawsuit. So now, guess what? If you're saying I owe you $800, you owe me $900 or $1,000. Now, with this step, you have to make sure you learn and know your state laws, because there are different statutes, different laws and limitations on what you can sue for in small claims court in your state. And my state I was in was New Jersey, so it go all the way up to $15,000 as being small claims court. So I would name them all in my lawsuit. I make sure you keep the amount low enough it ain't worth their time, but just high enough that you got more to lose than you have to gain. So when they do that, I name the board members, I name some customer service reps and the company, and then send the lawsuit directly to their offices. I will wait about 2 weeks to make sure they got served, call them up and see if they want to negotiate and remove this. Remember, they got this for pennies on a dollar. Plus, since they're LLC in many states, they can't represent themselves. They have to hire an attorney. And so this is very effective. COVID is being lifted. Many states, you have to show up in court. So that means their board members have to show up for this court date. They'll have to make arrangements. So this would make a tremendous amount of motivation for them to make this go away. So at that point, I'll call their legal department. They always have one because they get sued all the time. And you let them know, I got a lawsuit against you guys. Do you want to settle? They might have their attorney to call you, and they'll just threaten you a little bit. Oh, you didn't, they're saying this and that. And I'll say, hey, tell it to the judge. It is what it is. The judge, I got proof that defamation. I got things I got denied for. If you don't have this to the T that I owe you, the interest, can you calculate it? Oh, you ain't make that payment on that credit card. Did it over the phone. I paid online. They didn't apply that correctly. It was a 0% interest credit card when I got it. Oh, what's the proof that you didn't have a 0% interest credit card? They never send you that stuff certified in the mail. They, with the promotion, prove that. And prove your legal right as being a third party of collecting on that debt. Give me a signature. Many of them bow down, and it's just easier to make it go away. And so they'll just sign a form. You drop your lawsuit. You make sure when you're negotiating, they have to remove every negative reporting within 30 days from the credit bureaus and all CRAs. All of them. That means LexisNexis, a Novus, anyone y'all can name, remove that. And once they give you that letter and that settlement, sometimes you do have some credit bureaus that could be a little stubborn and don't remove it after the 30 days. But now you have a proof of this lawsuit, and they'll send you something in writing. Send that to the credit bureaus, and then they have to remove that collection. So that has been tremendously effective for me. But like I said, that doesn't constitute legal advice. You have to consult an attorney in your state to make sure you know your laws. But always remember, everybody have to have proof of what they're saying, okay? You have proof, which is your credit report on what they're reporting, and any denial letters that they have harmed you financially. So those are the 7 steps to help you remove a collection. Hopefully this is helpful. If you guys want to reach out to me, you can submit your personal questions at my website. They go directly to my cell phone, or you can leave your comments in the comments section and I will reply. So hopefully I'll see you guys in the next video.